Good afternoon and welcome to our series of MCA webinars. I really hope you've enjoyed them so far. All of the webinars are recorded and the slides are available after the talks. During the talk today, if you want to ask any questions, please look at the bar at the bottom of your screen. There should be a Q&A provision there. If you could ask any questions through that. So today I'm delighted that Sarah Castle is joining us. Sarah is the Official Solicitor and Public Trustee. She was appointed in July of 2019. She has a background in child protection. She's the first woman in this role. As the OS, she has a whole range of responsibilities and is here to talk about them today. So please welcome Sarah Castle. Thank you, Sarah.
Oh, thank you, Alison. Thank you for that lovely welcome. I'm delighted to be presenting to you this afternoon. It's a pity we're not all together in York, but I think this is a good way of us coming together. So when I was chatting to Alison in preparation for today, she said to me she thought that our audience would find it interesting to know a little bit more about what my role is, what I get up to. And I couldn't not talk about the effects of the pandemic. And I also this afternoon just want to do some horizon scanning to look what's in the future for the Office of the OS. So just a little bit about me. You'll see I was admitted in 1994. The whole of my professional working life has been in public service. I did my articles and I practiced in a local authority for 22 years before taking up the post of OSPT in 2019. And as Alison said, my area of specialism was child protection before taking up this post. And I have to say, I think my background has stood me in very good stead for the work that I now do. I come from Warwickshire. I'm a Midlander. I'm very proud of that. I went to Durham University and then did my finals in Chancery Lane. And I'm currently speaking to you from my home in South Oxfordshire, where I live with my husband and 2 stepchildren. So I'm very proud to be the first lady official solicitor. I've been in the role now for just over 18 months. And I'm the second woman to hold the office of the public trustee. I am a civil servant and I hold 2 separate independent statutory offices, and I have my articles of appointment signed by the Lord Chancellor of the day, who was David Gauke. I don't think he was around actually for much longer after he signed my articles. So this slide always amuses me because on the right we have the gentleman with the moustache is the first official solicitor, and I have his oil painting in my office. And on the left, the man in the bowler hats is the first public trustee. And then I obviously am the new version, and you can see looking very different. And every time I look at that photo, I think I really must get that redone. So I just want to mention this because it may interest some of you, particularly the lawyers on the call, because the office of the official solicitor first appeared in Samuel Pepys' diary, and the actual site of the office was in Chancery Lane, and it was actually on the site where the Law Society now is. And if you go into the Law Society and you turn right, you come to the restaurant bar, and it's called the 6 Clerks Bar, and that's why, because that's where the official solicitor's office, the 6 Clerks office, was based. And I think that's a very nice touch, and it has this lovely plaque actually in stone just outside the restaurant. Up until 2016, the public trustee office and the official solicitor's offices were completely separate, 2 separate office holders, 2 separate offices. And in 2016, they came together and combined into one office and one post. So I have members of my team who originally came from one or the other. So 2021 is a really big year for the OS because we celebrate 150 years of the role. And it had been our intention to hold a national conference to showcase and celebrate the work of the office, and also to celebrate both internally and externally. So we have had to rethink that. We've had to downscale our plans, but we still will be celebrating as far as we're able to. So just a little bit about the setup of our office. For those of you who don't know, I have a staff group of 138, and 28 of those are lawyers. The rest are very experienced case managers and administrative staff. People who come to work in OSPT, they often stay there for years, and as a result, I have a very committed and experienced team for which I am really grateful. I am supported by 2 deputy OSs and 1 deputy public trustee. My current senior leadership team, which is made up of senior legal and operational staff, are currently all women. So that's good, but we could deal with a couple of male voices, but at the moment we're an all-female team. My office is divided into 3 main areas of business: litigation services, trust and estates, and international work. I've got 2 international teams. I should imagine most of you on the call will be familiar with our litigation services, and they are divided into civil, of which we undertake around 35 different types of civil litigation, family, both private and public law, and court of protection, which includes the health and welfare and both the property and affairs cases. I am responsible for a number of trusts and are dealt with by my trust and estates team. And I have 2 international teams, which is work carried out on behalf of the Lord Chancellor. I am the Central Authority for England and Wales for children, and that therefore involves international child abduction and contact issues, and also the REMO unit, who are the reciprocal enforcement of maintenance orders. So as you can see, there is an awful lot going on. We only conduct in-house litigation in respect of 2 areas of work, those being the serious medical treatment cases and the property and affairs cases. For the remaining work, we retain private practice solicitors, and there may very well be a number of you on the call who undertake work on my behalf, and I thank you for that. I'm also appointed as advocate to the court, and I have a steady stream of those invitations, and I have a handful of invitations to conduct Harbin and Masterman inquiries each year. So when I think about what do I actually do, I consider that my role is divided into 4 parts. I have my internal management, my work with the Ministry of Justice, my stakeholder engagement, and my work as the public trustee. So what is my internal management? Well, OSPT is considered as an arm's length body of the Ministry of Justice. So I am independent in terms of the decisions I make on cases, and yet I am connected. I receive a large chunk of my budget from the MOJ, and we are also employed by the Ministry of Justice. So I spend my time managing staff and the business alongside giving direction on cases. And I've just put a note there that I'm consulted on the vast majority of instructions on the serious medical treatment cases. And you may have seen me pop up in the odd reported case that I do the odd bit of advocacy. For those of you involved in the family work, I personally approve, I think, about 80% of the position statements, which are for clients who clearly lack capacity in those proceedings. That is very much my comfort zone. I come from a family and child protection background, and therefore when I'm approving those statements, it very much takes me back to my previous work with the local authority. In respect of my work with the Ministry of Justice, this is a completely different dynamic for me. I am part of a senior leadership team that's currently led by a new role, actually. Second permanent secretary has very recently been created. That's now occupied by a lady called Jo Farrer, who's also the chief executive of HMPPS. Very interestingly, Jo's background is also in a local authority, and I'm very much looking forward to working with her. Along with OSPT, the other chief executives from the Office of the Public Guardian, the Legal Aid Agency, and Criminal Injuries Compensation Authority are all part of that group. And I have had invaluable support from the Ministry of Justice and my colleagues who I sit on this group with, and has created a lot of opportunities for me and my team. So how about stakeholder engagement? Well, I consider that being the official solicitor, I need to be outward facing as well as managing the internal business. A significant stakeholder for me is the judiciary. It was a main priority for me when I took up my post that I needed to form very, very firm and strong relationships with all of the judges, and I hope that I have achieved that. I have regular discussions with the president and the vice president, and our dialogue is very collaborative. I'm also part of the Hive group, which was created by the vice president in response to the pandemic, and I believe this group has been very effective in trying to navigate the court of protection through this lockdown. As part of the Hive, there are judges, senior counsel, solicitors, Office of the Public Guardian, and also policy colleagues from MOJ. MOJ policy are another significant stakeholder for me, and we work together on new work streams as well as existing policy issues. Just want to talk a little bit about the introduction of our out-of-hours service for the serious medical treatment cases, and that was born out of a request from the president and the vice president. They considered that it would be extremely helpful for the judges, the duty judges, to have the assistance of the OS where P was the applicant or certainly involved in the case. I responded to that, and I commissioned a pilot that we started in May of last year and confirmed in November that the pilot had been hugely successful, and it is now embedded in part of the service which we offer. I have listed 3 cases there. I'm not going to talk hugely this afternoon about the cases because there just are so many, and I know there have been lots of contributions to this series of seminars regarding case law and the updates, but I just want to touch on a few of them. And 2 weeks into the pilot, the case of MSP appears. I was at home Friday evening, and I get a call from the vice president saying, "Sarah, can you be part of a hearing in 10 minutes time?" And I said, "Of course." And that was the beginning of the MSP case. I consider it to be a very tragic case, a case about P's autonomy, and should effect be given to his wishes to refuse life-sustaining treatment. For those of you who are familiar with the case, P had made an advance direction, but it had not been witnessed. my submission to the court was yes, priority should be given to P's autonomy. The Vice President agreed, and the outcome will be obvious but extremely tragic. I will never forget that case. Not only was it the first out of hours case where the OS participated under the pilot, but it really resonated with me. He was a young man. He could have lived with a permanent stoma, but he had been clear to his family and clinicians that he could not face life in those circumstances. And he had been so clear, and the evidence was so compelling, that it was not difficult for me to confirm his wishes. I then give the citation for the more recent case of University Hospitals Plymouth NHS Trust and RS. I don't know how many of you on the call followed this case, but it started in mid-December. I became involved in an out-of-hours capacity on the bank holiday Monday following Christmas, and I lived and breathed it for the following 5 weeks. This case concerned the withdrawal of life-sustaining treatment in the context of a bitter dispute between family members and P's ascertainable past wishes and feelings. For those of you not familiar with it, if I say within a 5-week period, that case was heard 3 times by Cohen J in the Court of Protection, twice in the Court of Appeal, 4 times in Strasbourg in the European Court, and also a complaint was made to the United Nations. 2 of those hearings in the Court of Protection were out of hours. It was a very highly charged case and very difficult for all concerned. I can honestly say to you, I think I went to bed most of those evenings during those 5 weeks, wondering if I was going to be woken up by an out of hours application. I've included East Lancashire Hospital NHS Trust versus GH in there, because this was the most recent out of hours case that was heard. This was only a couple of weeks ago, and the case concerned whether an acutely agoraphobic woman in labour at home should be transferred to hospital against her will to deliver her baby. Prior to her losing capacity, she had been aware a hospital birth may happen, and she had consistently spoken about delivering a healthy baby. I advocated it was in P's best interest for her to be transported to hospital, and McDonald J agreed. And I'm pleased to say that P gave birth to her baby. I think it was a boy actually, gave birth to her baby safely very shortly thereafter. If ever I needed convincing that an out-of-hours service was necessary for the medical work, I need only reflect on those past 3 cases. So now changing tack to my role as the public trustee, and the lion's share of my contribution to this role is around my work with Chequers, the country home of the Prime Minister of the day, because I am a trustee of that lovely house and estate. I'm actually a custodian trustee, which means legal ownership of the house and estate vests in me. And every time I go, I think, if only. I'm part of the full board of trustees as well as the management committee, and I've greatly enjoyed getting to know and work with the staff. This year, we celebrate 100 years of the occupation of the House by a Prime Minister. When I applied for this role, and indeed when I was interviewed for this role, they didn't tell me about my role in Chequers. And it was only after I'd been offered the job that they said, well, a part of it is going to be involved with this house. And I just tell you a nice little story about when first time I went to the house. I was clearly very excited about it, and off I went, drove there, and I was met by a policeman, as you'd expect. And he said, "Yes, they're expecting you, Mom. Just drive up the drive and park in front of the house." And as I swept into the fabulous drive, all the staff were lined up on the steps like Downton Abbey. And I thought, right, Sarah, you have got to exit this car. You cannot become Bridget Jones. You have got to stride across this drive with confidence. And I made it to the door in one piece, and they gave me a tremendous welcome. And they continue to do so every time I go. So I didn't think I could speak to you all today without just talking a little bit about the impact of the pandemic, and not to dwell too heavily on it, but I just wanted to share some reflections with you. I think it has been truly tremendous how the whole system has pulled together, and we have tried our very best to keep the wheels of justice moving, and I include all of you on the call in that endeavour. I believe we were thrust into this, and I think it improved our stakeholder relationships. OSPT, we needed to actively participate in a number of key dial-ins, and some of them at the beginning of the pandemic were daily. We have, in some respects, made more progress over the past 12 months than we have made in years or were ever likely to make. And I think a fantastic example for us is our work with the banks and financial institutions. Prior to this, they refused to deal with us electronically, and they refused to speak to us on the phone. They insisted on hard copy communication. That has all now stopped, and happily, we are communicating by email. You may have heard the Vice President talk, Mr. Justice Hayden, on the issue of medical professionals giving their evidence from their hospital rooms while sitting in their scrubs. And I have to say, I wholeheartedly endorse his view that it is better quality evidence. It certainly has saved time for those professionals in dragging them to court, and there is more of a compelling nature to it in my view. I'd also say the same for family members. They've been able to give evidence from the comfort of their homes rather than being in what some may consider to be an intimidating courtroom. In that context, I want to mention the case of WA, the Avon and Wiltshire Mental Health Partnership in WA. I was appointed in that case as advocate to the court. Some of you may be familiar with it. The issue was whether P had capacity to make a decision about his nutrition and hydration, and if not, what approach should be taken. P was effectively on hunger strike, protesting against a decision regarding the Home Office age assessments and the age P had been assessed at. P had fled from Gaza. His grandmother had given him his date of birth just shortly before he fled his country, and he felt it was the last piece of identity that he had. He had truly suffered a traumatic journey to arrive in the UK, both of his parents having died, I think possibly in tragic circumstances. And he felt he'd been stripped of everything but his date of birth. The Vice President, again, this was a case heard by Mr. Justice Hayden. He found that P lacked capacity to make a decision about his nutrition and hydration, and the court approved a treatment plan, but no force feeding, and his refusal should be respected. At the time of the Court of Protection proceedings, there are also parallel JR proceedings, and I understand he's obviously gone up through the tiers, and I understand that he has been granted permission to appeal to the Supreme Court. So we'll have to anxiously await the outcome of that. The reason for me including that case in my presentation this afternoon is this was such a fantastic example of the participation of P during the pandemic. It's a fantastic example of how Mr. Justice Hayden sought to involve P, engage with him, visit him with P virtually, by P sitting in his hospital bed with the support of his truly lovely foster parents. And P was able to participate. And I think he will really have appreciated the care and the rapport with which Mr. Justice Hayden dealt with that. What I would say about the conduct both of our work from our office model and our court of protection model is that some aspects of it, I truly believe that we will not go back to how it was before. So just very briefly, what did certainly the OSPT learn? Well, we learned that we can operate very effectively remotely, and I'm sure you have all found that also. Thank goodness we've got good IT. I dread to think what a state the system would have been in had we not all had that. My staff have demonstrated fantastic flexibility, and we've tried to be as mindful as we possibly can and prioritise our staff's well-being. Just want to reflect a little bit on the impact of the pandemic on our clients, on vulnerable people. And I think we're only just beginning to see the effects of it. I don't think we've seen anything yet. We know that the effects of the pandemic have affected many people's mental health. And I anticipate that I'm going to see an increase of work across all of my litigation teams. And I've just tried to bullet point just a few areas where I think it's going to be quite challenging around, once the lid is fully lifted, around eviction proceedings, on budgetary considerations which may lead to more challenges on failure to provide housing and social care. In preparation for today, myself and some of my team were looking at all the cases that we've been involved in the past 12 months. And there have been many, and there have been some truly fantastic cases, very interesting decisions. And I've prepared a handout. It only, I say only, amounts to 3 sides, but it's jam-packed, to be honest, and hopefully that can be circulated. So there's the citations as well as the key issue in the case. But when I looked at it, I thought, goodness me, we have achieved a lot in the past 12 months. So what is on the horizon? I could not talk to you about ReJB. I'm sure many of you will be very familiar with the case. We have, and just for those who are not familiar, this is the Court of Appeal decision last year, which looked at and indeed changed the test for, does P have the, even though the test is now, does P have the capacity to decide to engage in sexual relations? It's all around the capacity to consent to sexual relations. We have made an application to the Supreme Court for permission. We made that several months ago. We have not yet heard as to whether we have been successful. I remain cautiously optimistic, but I can put it no higher than that. I think if we are successful, then it's going to be a very interesting case, because we do not have any Supreme Court justices at the moment who have a background in family or court of protection. So it's going to be very interesting to see how that pans out. But I really hope that we're able to reconsider this case and to examine it more closely. I've put the citation there for the JR I was involved in earlier last year concerning the parole board. The decision, the outcome of that case was that the OS can act in parole board cases. I've already started to accept some of that work representing prisoners who lack capacity in those circumstances, and my team are working with the MOJ policy colleagues and the parole board in finalising guidance, but this is going to be a new work stream for the OS. I haven't actually put it as a bullet point, but a further work stream is also, I'm going to become the central authority for adults as well as children. So my ICACU team, one of my international teams, is going to be heavily involved in that, and that's undertaking further work on behalf of the Lord Chancellor. We are receiving an increasing number of inquiries about tribunals work. We do, in very exceptional circumstances, represent litigants in tribunals, but I anticipate that moving forward, that will become a more prevalent area of our work. And I've just listed there the AM Afghanistan decision, which refers to the potential for the OS to become involved with tribunal work. Just a mention here, in terms of horizon scanning, what do we need to keep an eye on? And one thing being the legal aid means test review, which will commence this spring by the Ministry of Justice. And they will report to government by the end of the year. A lady called Phoebe Clapham is undertaking this work on behalf of the MOJ. It will cover various work streams, including the one I'm really interested in, which is non-means tested areas. So we will have to keep an eye on that and see what happens. My final point is a mention about what the Hive are getting up to. The Vice President has commissioned a working group of which I am part, which is going to look into the practices which have developed during the course of the pandemic, and which of those practices do we want to keep indefinitely. There will be a strong emphasis here on the part played by technology and remote hearings and the implications for the participation of P. And I'm very pleased to say that we have very good representation from the judiciary, senior counsel, solicitors, OSPT and the Office of the Public Guardian, who now are going to take this work forward and hopefully report late spring, early summer. So that seems quite a lot to trot through, but as you can see, my role is extremely varied. I'm enjoying it enormously. I feel I have inherited a fantastic team. I feel extremely lucky. They are experienced, as I've said, they are committed. They really love doing the work, and it's fantastic work. And for those of you who are involved with our office, I hope you share that. So, Alison, I think I've come to the end, but I'm very happy to take any questions.
Thank you very much, Sarah. That was extremely interesting. your slides and the case law that the cases that the EOS has been involved in for the last 12 months, I think you said, is going to be made available to everybody. So that's really useful as well. So I can see you perfectly now.
That's okay.
That's brilliant. The first question is, I think you might have answered it, but we'll repeat it again. So the Hive group, how often do they meet and what are the ongoing discussions?
Oh wow, good question. It's I have to say it's pretty random. We meet probably every couple of months, but we can dip in and out of it. You know, the VP can contact us all and say, can you make a meeting next week? So it's fairly flexible, it's fairly fluid, to be honest. But I think he has found it of enormous assistance. And we talk about the challenges of the remote hearing, of transparency, about the practicalities, about preparation for these hearings, how we've really got to get to the key issues as quickly as we can when presenting these cases. The VP will produce guidance on occasion that from our discussions, what may flow from that, he may say, well, actually, I think I need to provide some guidance on that to assist practitioners. So my experience of it's both forward-thinking and reactive. It has a dual aspect to it, and I think it's worked really well, and I'm really excited to be part of this now. What do we keep post-pandemic? What has worked? You know, a fantastic example is, do we need to drag experts to court anymore? You know, it's create, you know, they need to be in their hospitals, they can equally do it well from their office, and I can't see that changing.
Which nicely segues into the next question, which is, do you think the new innovative way of dealing with evidence will stick?
I hope, well, yes, I hope. I mean, this working party is going to examine that. It's going to look at that, and I think the composition of that working group is very well placed to look at that. So I think we have got to really harness some of the innovation and some of the progress that we've made in recent months. We can't lose that. And I would do my best to be part of that voice. It's not without its challenges for P, I have to say.
That again is a question: how does this impact on P
really
and the participation of P?
I think I've responded to 2 consultations in family justice and in civil justice, setting out my concerns that, particularly at the beginning of lockdown, you know, P, I think our clients gain a lot of support from their legal team, from being able to help them understand what's going on, and it's so much that is packaged in that direct contact. And it was a great concern to me how P was you know, meant to access the tech. Did they have a phone? Did they have you know, all of that? So I think that remains a challenge. But as the restrictions become a bit more flexible, obviously that becomes less challenging. But at the very beginning, I was very exercised about P being very isolated and, you know, potentially them giving up or losing heart through the process.
Yeah.
I think the serious medical treatment cases are a slightly different kettle of fish, to be honest, because I think the judges, and I think the master of this is the VP, and how the judges have tried very hard to include P by visiting them wherever they may be, virtually, and often in hospital.
Yeah.
And I've witnessed myself, I've been part of hearings when it's been a very powerful exercise. And I gave WA as, I think, my best example of that, because had the hospital not being able to cooperate with, assisting with the tech, and the VP not being so insistent on it, I think we would have lost who WA was.
Yeah.
And to see him and hear him on the screen, I think made a significant contribution to the case.
Yeah. Yeah.
So it's not without its challenges. All judges are different as well, but I think it's been remarkable what's been achieved.
The next question is, how often is the out-of-hours service called upon?
Well, it's gathering pace, I can say. When we had a couple of cases at the beginning, MSP being one of them, and then we had quite a quiet period. It went for several weeks, and then it pops up again. So I think it's how many cases have we had since the pilot? I would say we've probably had about 8. You can see when they come, they're big cases.
They're heavy cases, aren't they? Yeah.
They're heavy cases. The judges are the gatekeepers. They make the decision as to whether we need to be called. I think they have dealt with that very responsibly, and I'm very grateful to them. Friday nights is the danger zone, Friday nights I'm really looking more intently at my phone as to whether we're going to get a call. But we now have a number of lawyers in OSPT who are part of the out-of-hours service, and they're all incredibly experienced. I take the call myself. It starts with me, and then I have a senior lawyer constantly on the rota with me, and then rotated are other of our lawyers. So I think it's working well. Mm-hmm. The feedback from the judges is very positive.
Thank you. And the next question is, has the appointment of the of ALRs taken some of the pressure from the COP lawyers in your office?
Well, I would say not as much as we had anticipated. I mean,
that's interesting.
Yes, I mean that's the feedback. So yes, I think we thought that there would be more, but maybe I don't know. I'd be interested to have a two-way dialogue about that. I don't know.
I think the rollout of the appointment of ALRs and the accreditation has been obviously impacted adversely by COVID. So it may well be that we haven't got a true picture yet.
Yes, and maybe when we come together again, I'm sure we will in York before too long. That's an area that we can revisit and see, with the lifting of the restrictions and life getting going again, whether that also gathers pace.
And the next question is, where the official solicitor is acting in welfare or serious medical treatment cases, does anyone from the team visit or make contact with P? I think you've answered that one already.
Oh, they do, yes, absolutely. It's a vital, well, we're certainly in the serious medical treatment cases, absolutely, yes. If it's out of hours, it just depends on whether time permits, Sorry, Alison, was it in the context of out of hours or normal work?
No, I think it's normal work, actually.
Absolutely,
but serious medical treatment, it doesn't actually specify whether it's on an emergency basis.
It's absolutely core part of that area of work. Yeah, that our lawyers will try and engage as much as possible with P. We use practitioners in terms of visitors if geography doesn't allow. We're very ably assisted in that regard. But yes, it's crucial. It's crucial because we have to establish P's wishes and feelings. It's at the heart of what we do.
Thank you, Sarah. Does the Official Solicitor act in Mental Health Act applications to displace nearest relatives when the patient lacks capacity to litigate?
No, that's local authorities. I'm just thinking about that. whether we do. We may represent P actually in those circumstances. It's not an aspect of the work that I have become involved in to date. So I'm just thinking about it. I'm sure we do. Sorry, I should know that, shouldn't I? But
don't worry. I'm sure we can qualify that. The next question is, there are times when we feel that the RPR and not the official solicitor are better placed to support P, I think it should say as litigation friend, in applications to the COP. What are your thoughts?
Well, I think I am the litigation friend of last resort. And I think it's a matter for the judge. I'm not opposed to it. I think whoever can best represent P's position. Yeah. So I don't say it has to be me.
Sorry, Sarah, to cut across. The next question is, have the new work streams also included an increase in the budget of the Office of the OSPG?
Well, that's a thorny issue, isn't it? How can I put this? I certainly think I'm going to be able to deliver on the new work streams. I have a good relationship with the MOJ. I think since I've taken up my office, they have been very responsive to increased demands, and I'm going to be able to deliver the new work streams if I can put it in those terms. So I'm not awake at night thinking, am I going to be able to deliver it?
Thank you. Those are all the questions we have on the live chat, Sarah. So I think, yes, that's right. So can I just say thank you so much for your time this afternoon. It's been an extremely interesting talk, and I hope to see you very soon in real life. Thank you very much, Sarah. I hope everybody's enjoyed it. Thank you.
That's a pleasure. Thank you, Alison, and thank you everyone for joining. I hope that you found it interesting.
Thank you.